Welcome to the deep dive. We take those dense legal texts and try to make sense of them for you. Today, our mission is tackling a classic clash. A big company, PLDT, wanting to keep old tax breaks versus local government, Laguna in this case, wanting its share.
Exactly. This all centers on PLDT trying to get a refund for local franchise taxes, specifically for 1998 and 1999. See, PLDT had this old franchise, RA 7082, saying they pay 3% of receipts, and that was it. In lieu of all taxes, it said, like a shield.
Right, a pretty sweet deal for them. But that shield got, well, seriously dented around 1992.
January 1st, 92, that's when the Local Government Code, or LGC, came into force, RA 7160. And this was big. It was all about decentralization. Section 137 gave provinces, cities, the power to levy their own local franchise taxes.
Okay, so decentralization means local power.
And here's the real kicker. Section 193 of that same LGC, it pretty much wiped the slate clean, explicitly withdrew nearly all existing tax exemptions that companies had.
So the LGC basically said, PLDT, that old 3% deal, time's up. But PLDT didn't just roll over. This case against Laguna, wasn't this their third go-around? They'd already lost against Davao and Bacolod.
That's right, third attempt. So they needed a different strategy this time. They couldn't rely on the old franchise anymore, so they switched gears. They pinned their hopes on a newer law, the Public Telecommunications Policy Act of 1995, RA 7925.
Oh, okay. And within that act, there was something specific they latched onto.
Yes, Section 23. It's often called the Most Favored Treatment Clause, or sometimes Level Playing Field Clause.
Okay, let's unpack that. Most favored treatment.
Yeah.
What was PLDT's argument there?
Well, they argued that if any other telecom company, maybe a newer one like Smart or Globe, got a franchise after the LGC came in, and that new franchise happened to grant an exemption from local taxes, then PLDT should automatically get that same exemption, ipso facto, as they say.
Like a Me Too clause for tax breaks. If my competitor gets a perk, I get it too.
Essentially, yes. It's clever. And, it actually seemed to work for a bit. The Department of Finance's Bureau of Local Government Finance, the BLGF, they put out a ruling in 98 siding with PLDT, said they were exempt from local tax starting in 95 because of that clause.
So they had an administrative ruling in their favor. Why did the Supreme Court slam the door on this then? Not just once, but consistently.
Well, the court pulled out some pretty fundamental legal principles. First, the big one. Tax exemptions are highly disfavored. Meaning, if a law is going to grant an exemption from paying taxes, it has to be incredibly explicit. Clear, unambiguous language, no room for doubt.
And any doubt goes in favor of?
The government, the taxing authority, not the taxpayer seeking the exemption.
So the court looked at Section 23's mention of exemption, privilege, immunity, and said, this isn't clear enough. It doesn't explicitly say tax exemption.
Precisely. They interpreted exemption in Section 23 differently. They said it referred to exemptions from certain regulatory requirements, things the National Telecommunications Commission might impose, like maybe rules about permits or technical standards or these equal access clauses. Operational stuff, not fiscal stuff.
Okay, so that's the first reason, strict interpretation against exemptions. What else did the court rely on? You mentioned rejecting the consequences.
Yes, the absurd consequences argument. The court basically game-planned PLDT's theory. They said, look, if we agree with PLDT, think about what happens every time Congress grants a new franchise to any telecom company with slightly different, maybe lower tax terms. The government would instantly have to adjust everyone else's tax liability, PLDT, Globe, Smart, that all claim that new, lower rate under Section 23. It would mean constant recalculations, potential refunds. The court saw it as totally unworkable, an administrative nightmare trying to keep that playing field perfectly level tax-wise.
So that sounds chaotic.
Yeah.
And what about that BLGF ruling that seemed to back PLDT up? How did the court handle that?
They set it aside. They clarified the BLGF's rule. It's consultative, advisory, it helps local governments, but it's not a court. Interpreting what a law means, what Congress intended with RA 7925, that's a legal question. That's the job of the judiciary, specifically the Supreme Court in this instance.
Got it. So bottom line, the trial court was right, no refund for PLDT. They had to pay the local franchise tax to Laguna for 98 and 99.
Correct. The Supreme Court affirmed the denial.
So the key takeaway for you listening is pretty stark. When you have a conflict between laws like the LGC taking away exemptions and another law like RA 7925 granting favors the power to tax, especially local taxation under the LGC, usually wins. And the principle of strict construction against tax exemptions is powerful. Unless the legislature uses neon signs saying this is a tax exemption, courts are likely to rule against it.
Mm-hmm. And that leaves us with a final thought for you to ponder. Section 23, that most favored treatment clause. The law itself says that equality doesn't apply to certain big things. The territory a franchise covers, how long it lasts, or the specific type of service authorized, Congress listed those exclusions.
Okay.
So if Congress carved out those major commercial elements, and the court has now said local taxation isn't covered either, what real tangible advantages are left? What kind of favors or privileges do these telecom giants actually get to share under this Section 23? What's the practical bite of that clause today? Something to think about.